Brandon Darrell King, is that your true and correct name?
Yes, ma'am.
This is case 24 FE 006617, offense date April 17th, 2024. Count 1 alleges robbery in violation of Penal Code 211. Count 2, willfully causing or permitting an elder dependent to be to adult abuse. The violation of Penal Code section 368 per NB per N1. Count 3, vandalism in violation of Penal Code section 594. Public defender's appointed.
60 days to cover public defender's office, accepting appointment. It is by understated order to prepare to release Mr. King on pretrial release level 5.
For the record, the people are objecting. I'm concerned for public safety based on the conduct. He entered a market that was owned by a 73-year-old individual who is a victim in this case. He started to take items, food items, and shove them down his pants. The victim confronted the defendant as he did this inside the market. He then shoved her and knocked her over, and then I think also damaged some wine bottles within the store and damaged the door to the store. He is on a recent grant of felony probation for a 459 second degree, 2 years county jail prison. Based on all of that, I would object.
Mr. King, I am going to release you on pretrial conditions. Mr. King?
Yes, I can pay for the date to be withdrawn.
All right, sir,
You have to
look at me real quick. I'm gonna release you, but I'm gonna release you on conditions, and I want to make sure you hear and understand those conditions, okay?
Yes.
All right, so if you need to check in with pretrial services, at least 2 check-in phone calls per month, in addition to court date reminders, you're to provide your current address and phone number to pretrial services. If you change your address, phone number, or employment status, you need to let pretrial services know immediately. It's your responsibility to make sure that they know how to get a hold of you. What have I said to you so far, sir?
Check in 2 times a month prior to going to, excuse me,
No worries.
prior to going to court where I spoke to, I was trying to pay for it and get that withdrawn.
Well, we don't want to talk about the facts of the case, sir, okay?
Yes.
All right, so I want to make sure I'm going to go slowly with you, okay? Just to make sure you got the first part. But what I need you also to do is when you check in with them, you got to give them your address and phone number. You got that?
Yes.
Okay. And if you change your address and phone number, you need to let them know immediately. It's your responsibility to make sure they know how to get a hold of that. Do you understand that? Mr. King?
Yes, I understand that.
Okay. You have to obey all laws. You've got me so far?
Yes.
And you're gonna be subject to search and seizure of your person, your residence, and your vehicle by any peace officer without a warrant.
I'm not from that country, ma'am. That's why I was wondering how come I was not in that country that you're trying to allow me to. I was in a different country, and then my country leader is going to respond to you by that.
All right, Mr. King, you're causing the court some.
Yes, I understand. Yes, I understand. I understand. If they want to do that prior to that country, then I understand. If I'm in that country, I
So
understand.
here's what I'm saying to you.
Yes, I understand. I understand.
Hold on, okay? Listen, sir, I'm trying to let you out of custody,
Yes, I understand.
and I'm trying to get so that you can go home.
I understand.
I'm not convinced that you do, sir.
Yes, I understand. I
Mr.
understand.
Chairman, what I want to make sure, I'm not changing my mind.
No, I
I
understand. You said search and procedure, and then that'd be okay. I just didn't want,
Here's what I'm gonna do, Mr. King.
I just didn't want to mess this up for me being released today. I understand. That's what,
I know.
that's what my point is. I understand the language. I understand that I must get search and seizure. And then I understand that part. I was just saying, I do not want to go mess with them.
Okay, well, that's good. I don't want you to mess with them, but what I'm gonna do for just a second is I'm gonna pass this matter. I'm gonna let Mr. Clemmer give you a little bit more of time to talk to you. Make sure that we're all on the same page, and when we come back, we're gonna see if you understand and agree. It's gonna happen today, sir.
I said I can be released. I was saying I didn't want to mess with that lady no more.
Okay, don't argue with her because she's the one who's letting you out. Come talk to me.
Oh, it's just gonna be a few minutes, sir. We're not going any further than that, just a few minutes.
My second was 2 times a month.
Recalling 26 King.
All right, returning to Mr. King. Mr. King, you had a little bit of time to talk with Mr. Clemmer. Mr. Clemmer, Do you, after having further discussions with Mr. King, feel that he properly understands what the court's orders are?
Yes,
Mr. King, do you understand and agree to the conditions I have for your release?
Yes, ma'am, I do understand.
All right, and you agreed to follow those conditions?
Yes, ma'am.
And what's the next court date, Mr. Clement?
do we have May 20th, 8:30, Department 63?
May 20th, 8:30, 63. Mr. King, you're ordered to return back to court here on May 20th, 8:30, Department 63.
Yes, ma'am.
All right, hang in there, sir, okay?
Yeah. Judge, did you impose a stay away order or no contact order with the victim?
No, because we didn't talk about it in court, or during our pre-trial.
Based on the charges and my objection, I would ask that you do so. I
I didn't get your objection on the record, I'm sorry, we were trying to deal with all of it, or did I?
think we did.
Okay.
Yes.
What's the, what are you?
The stay away would be from 2800 T Street. That's the location of the robbery. And then I would ask for a no contact verbally as a condition of his release with the following individual. First name is spelled Satyajit. Last name is Sidhu, Sidhu.
Okay, so, sir, I'm actually gonna amend my order here. You're also not allowed to go back to the location of 2800 T Street in Sacramento, so you can't go there, sir, okay? If you go there, that'll be a violation of your release. You're also to stay away from, Sajit, Satyajit, Sidhu, Sidhu. Do you understand the terms and conditions of your release, sir?
Yes.
All right, that'll be the order.
Is this pre-trial? Yeah, pre-trial. He's gonna go over to 60. So, sir, I'm gonna have.
Gina Schner.
I am.
Pardon me, your home address, please?
2.
Thank you. Date of birth, please?
12,
And how old are you now?
60 years old.
Do you read, write, and understand English language?
I do.
How far did you go to school?
Graduated, but a few little other extra that didn't go far.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Please listen while state reads the charge of possible penalty.
On or about the 22nd day of February 2024 in the county of LaPorte, state of Indiana, Gina Schner did unlawfully, knowingly, or intentionally place a 911 call for the purpose other than obtaining public safety assistance or emergency services. That is a Class A misdemeanor carrying 0 to 365 days in the county jail and up to a $5,000 fine.
Do you understand the charge of the
I
possible
do,
penalty?
Your Honor.
All right. Are you planning to hire an attorney?
I have an unusual request. I feel like that I would like to schedule a conference with the prosecutor and maybe yourself as a mediator.
No.
Oh, I want to represent myself in this because I don't think there was any criminal intent in this at all.
Well, here's what I'm gonna do. I'm gonna give you some time to talk to an attorney. I'm gonna give you 3 weeks. I don't know if the state will visit with you personally or not. In most cases, they won't. But they would talk to your attorney. In 3 weeks, you're either gonna have a lawyer or you decide whether you want a bench trial or a jury trial.
Okay. All right.
May 8th at 4 p.m. Okay.
Next, state of Indiana.
No, he said. Yeah, so I have kittens and one of them pulled my mic cord out. Just a tiny itsy bitsy little bit. But that was enough. What I said, that I wanted to give a shout out to Tara Beard. She's not in chat here, but she's great. Tara Beard, you're great. Okay, we're going to stay with this Judge, for one more. One more good one.
Make a Monday. Good. I'm sure you get that
Next,
part
Stephen
done.
Ambrose,
Okay.
Katie Mullins,
All right. Okay, appreciate it.
46-03-2403 CM 678.
Take your time.
Thanks, my son. It's gonna be a while, we're together 46 years, or it's gonna be her, she passed me 15.
I don't know what he's
My
saying.
condolences, sir.
Honestly, I don't know why I'm here. Honestly, I got my paperwork, sir.
Hold on, we'll get there. Are you Jimmy Mullins?
Yes, sir.
Where do you live?
I don't, honestly, I'm not trying to be smart. Actually, I don't, I know where I live. Fort Indiana 46350,
He's
but
so
the police
cute.
think I live at 16.
He's just so cute.
That's my son.
All right,
My son's 44
So-
years old. I'm
so-
66.
so give me your address again. Thank you. What's your date of birth?
That's July 21st, 58.
And you're 65.
Yes, sir.
All right, well, let's see what we got going. So I gave you a form to fill out. Did you fill out that form?
Yes, and yes, sir. And
Okay.
I left it in my car a couple Saturdays ago, and I left the window halfway down, and sir, it rained cats and dogs, as they say. And all my paperwork got wet, but I saved it. I put it out in the sun, let it dry a little bit, but it was legible. I turned it into the clerk. I got a copy of everything
All right.
where they stamped it.
All right, well, let me see it. Let me see your copy.
Well, I don't know if I got it with me, but the stamp is, it's so, you ain't gonna be able to read that stamp, I know. But they got a copy of it in the clerk's office.
I know, David.
Oh, I'm sorry, sir, that's the case that's fair now to me. And I don't understand it, I don't understand why.
I'm gonna give you another form. Keep it dry. Get it
One
filled
thing
out.
they get, can I say something, sir?
Yeah.
Sir?
What's that?
I don't understand what criminal trespassing is. I understand it, that criminal trespassing, but I don't understand why, because it says not having, I don't understand that word. And I asked the clerk, and she told me the same thing that everything wrote down. I don't understand that word. Contractual or whatever. I don't understand that.
Mr. Mullins, we're working on getting you a lawyer who'll explain all that to you.
Well, anyhow, I know that the only thing is I was supposed to ask for a continuous so I can, tell the attorney about my story, but trouble is I asked for
All right,
my,
well, yeah, I'm gonna give
I already
you.
got a continuous.
What date you have?
May 3rd,
Okay. So you've got till May 3rd to either hire a lawyer or bring me that form filled out.
I wanted to say that, I wanted to get a court-appointed lawyer, please.
That's what that form is for.
Okay, thank you.
All right, we'll see you on May 3rd, sir.
I got so much paperwork. I got my life in my car. I lost, matter of fact, I lost 2 years, well, over 2 years now. I remember December, right before Christmas of 20, I didn't wake up until March,
I love
a
him.
week before my son's birthday, March of 23.
Mr. Mullins, all these folks are waiting their turn.
Yes, sir. I'm
Have a
sorry,
good day.
sir.
Next, State of Indiana versus Harry Shaw.
Judge, that was mean. I was listening to him. Hi, Julie Cat. Oh, Julie Cat. Okay, I love all 3 of your dogs, all of them. I really do. But your border collie, oh my gosh, so freaking cute. Oh man. Okay, let's not be saying yuck to beer now, Cloud. Come on now. You can at least say root beer is good. All right, we're going to Colorado. angry Colorado. Yeah. Butler's going to be here, guys. Don't worry. We're going to see Butler. Oh, wait. Hold on. I might be wrong, and I'm positive I will hear comments if I am. But I'm pretty damn sure this guy is the same guy that we saw in Colorado before. Hi, Fletcher, who wanted $1 million for his dogs. Like his service dogs were taken from him, and then he lost $1 million because of that. And then he dropped it down to like 500,000. He's like, I want the city to pay me 500,000 for these dogs. Okay. It might not be the same guy, but I think it is.
Good morning, everyone.
Morning, Judge.
Butler, are we ready to proceed?
We are ready to call Shawn Ambrose's cases.
All right, let's go ahead and call Mr. Ambrose's cases. Good morning, Mr. Ambrose.
Good morning, Judge. Good to see you.
You as well, sir. Perhaps Ms. Butler can share with us where we are with Mr. Ambrose's cases.
Thank you, Your Honor. So I just met with Mr. Ambrose. I advised him of the charges in these cases, as well as what the current offer is and what his rights are. Mr. Ambrose does not wish to accept the offer and resolve his cases today. It's my understanding that he is not automatically entitled to a PR bond in these cases based on the charges. And so therefore we would be asking to make a bond argument and requesting a PR bond in these matters.
Okay, why don't you go ahead then, Ms. Butler, and make your argument, and then we'll give Ms. Keller an opportunity to respond.
Thank you, Your Honor. So I did let Mr. Ambrose know that after I was done with my argument, if there was anything additional that he wanted to add, that he would have the right to kind of supplement any additional information. So there were a couple of things that we discussed as it pertains to Mr. Ambrose's current situation. He has, I'll start with his mental health, the state of his mental health. He has a number of mental health issues. He has been working with a therapist at Mental Health Partners. I believe his therapist's name is Rachel, is what he indicated to me. Being in custody seems to really exacerbate his mental health issues and state of mind. He did make some statements that, you know, his anxiety has been increasingly far worse. He's reached the point of feeling suicidal while he's been in custody, and he that's his main kind of concern for himself and reason that he wants to be get out of custody. In addition to that, he did indicate to me that he has a number of prescription medications that he should be taking to assist with these mental health issues and some other medical concerns that he suffers with. And he has not been able to take those prescription medications while he's at the jail. He told me that the officers had taken those medicines away from him, and they won't give it to him while he's in custody. He has a very close relationship with his mother, although she does live in Newport Beach, California. He told me that he talks to her every day, and told me that he can only imagine that she is concerned for his well-being, considering that he has not heard from him today or since he's been in custody. As far as his involvement with the community, Mr. Ambrose told me that he has received a master's in psychology at from the Seattle University. And while in Boulder, he works what he calls a critical incidental response team, helping the homeless and indigenous populations of Boulder get the resources that they need and kind of help them with whatever issues they are currently going through. He also has indicated to me that through this work, he has worked closely with professors and affiliates of the university. I'm not sure exactly what the details of what that work entails or includes, but that is kind of his involvement with the community. So I will leave it at that. I will, based on that, I would ask for a PR bond to be issued in these cases. I will turn it over to Mr. Ambrose if he has anything additional that he would like to add.
Thank you. The only thing additional I'd like to add is just, I mean, I've met you, Judge, and you know me, and I'm working on my cases, and I'm doing everything I possibly can in my power to be an upright citizen or whatnot, and this police force continues to abuse me. I've been mishandled by them multiple times. I've had my service animals taken multiple times. I've been put in jail for nonsensical things, and it has now caused me to incur multiple mental health diseases. As Lauren was referring to explain that a bit more in depth, I now have an eating disorder, complex PTSD that has led to multiple panic attacks. I am not suicidal yet, but I cannot be in confined spaces or else I get claustrophobia, OCD, and my body starts to shut down and I cannot eat. And if I do eat, the food here is basically, it's not poison, but it's not healthy. And so it causes my body to revert into a state of purging and gorging. This has all happened in the last 9 months. And over that 9 months, I was with my service animals, which are legally certified, and they were illegally taken by the Boulder Police Department 5 times. That cost me over $250,000 and is why I'm still stuck here. The police don't actually know where my wolves are. They're the wolf hybrids. They will not tell me. I've had to argue with the Attorney General to just be able to have dogs in my possession. Now, all of this at a Supreme Court level, I'm pretty sure is completely illegal. So I don't know the law like y'all do, but I do know human decency. And I know how human decency fits with psychology and how psychology fits with law. So at this point, I would like to be released from this jail as soon as possible, or else you're going to generate more health problems for me. And that is just, I mean, let's be human here. That's not fair. I picked a flower yesterday that I was actually going to replant, and an officer assaulted me. Now that officer is going to have nothing happen to them. Well, I've had to spend the last 24 hours in solitary or in confinement and not be able to have access to my own medications, my own foods, and my own well-being supplies. So at this point, like a PR bond, I think is well-deserved. And I would like to be able to leave by this afternoon if that's possible, so I do not have to deal with any more of my physical and mental health issues flaring up. Thank you.
Okay, thank you, Mr. Ambrose. Ms. Keller, response from the people.
Yeah, Your Honor, we would maintain our objection to the PR bond in this case, in all of these cases. All of these cases do have state misdemeanor equivalents that do give the court the authority to do so. In addition, all of these cases involve someone of authority asking Mr. Ambrose to do something several times, whether it's leave Rosetta Hall, leave the Boulder bookstore, clean up his tent, and all of that was refused multiple times by Mr. Ambrose. Mr. Ambrose, if you could please let me finish, I would appreciate it.
Sure.
Thank you.
And then we'll give you a chance if you want to respond again. Okay.
Reading the officer notes, Mr. Ambrose was also verbally antagonistic with the officer. and the owner of these establishments. Finally, in all of these cases, Mr. Ambrose has previously failed to appear in the municipal court. All of these cases do include a failure to appear note in full court. So we don't really have any assurance that he will actually come back to court should he be released on a PR bond. We certainly want him to be successful. We want him to be able to access his medications, but we also do need to be able to resolve these cases and hold him accountable for his actions.
All right, thank you, Ms. Keller. And Mr. Ambrose or Ms. Butler, any additional comments I'll be happy to hear. Go ahead, Mr. Ambrose.
Mr. Ambrose,
I apologize.
I just want to advise you not to comment on any of the allegations or the facts that were discussed about these cases. That would be my legal advice to you as your attorney.
That's fine. I appreciate that. I know this judge, and they're a fair judge. What has been said is not completely true. I have been compliant up to a point. I have listened to officers. I have formed friends on this that are on the Boulder PD. At this point, y'all, like, this legal, like, shit's failing me. Like, I'm an upright citizen. I used to work with zero. Like, I don't know what y'all want me to do. This is not fair. The city of Boulder has failed me. My mom was born in Denver. My grandparents met on Mapleton. I don't know what to do with y'all at this point. I've dedicated my life to healing and helping people, and now y'all, I'm sorry, I can't help but get emotional. Y'all are making, there's body cam footage at this point. Like, Miss Keller, you can say what you want. You have no idea what it's like to be a homeless person and have to try and make it to your court date and not know which court to go to. I have tried as hard as I can to follow the law here, and I have been continually abused and manipulated by its local representatives.
Stop breaking the law.
They were asking me for respect and patience yesterday, which I gave them. And then they brought me to jail. So I don't know what to ask for anymore from y'all. I just need help. I've been begging for help for a long while, and the jail does not help. It makes things worse. It's my final comment.
Okay, give me a moment. I wanted to look through each of the cases as far as the history and the cases that was referenced by Ms. Keller. So I'm going to go off camera for just a moment. I'll be right back with everyone.
Thank you, Judge.
I left it play so we can watch him because he is a great actor. And don't worry, it gets way worse. This clip just keeps getting worse. That's my new ringtone. The judge is coming right back, don't worry.
Okay, we are back on the record. We took a brief recess so that I could review the case history for Mr. Ambrose, and all of the things actually that Mr. Ambrose and his counsel said are concerns that a judge has. I empathize greatly with what circumstance you're experiencing, Mr. Ambrose, to be in custody, to be struggling with the mental health challenges that arise, partly because of being out on the streets, and then partly because when you get into custody, it can be a little bit overwhelming. I know that to be true. I'm not in any way naive to that fact. It's really a troubling circumstance that we have. And yet there are 3 separate cases, where I've already done PR bonds on those cases and couldn't get you to be in the courtroom. I know it's a struggle when you're out there to get to court, and that's why we try to be as flexible as we can. But there does come a point where I can't do much else but to move forward with the cases, to get resolution for the community at large, and for the prosecution's office out of fairness to resolve these cases. So I can't grant PR bonds on those cases.
Your Honor, I'm sorry to interrupt you. I just needed to make the court aware. We don't have holds on him for our cases, but he does have 3 cases that are holding him there, 2 state charges, and then a Netherlands Muni court case.
Yes, but also I think we also have warrants that are in the pipeline for failing to appear last week. So
last week.
That's right. Yeah.
I just wanted to make sure that his attorney was aware that he has other charges pending also.
I didn't have a court date last week. My court date is May 14th. Y'all are incorrect. Hello?
I'm listening to you, but I'm also I'm hearing Ms. Aubrey talk about other things, and I appreciate her jumping in to make sure everybody's clear. And I'm also trying to navigate and looking at, I don't see anything scheduled for May 14th in one case. I'm going to look through all of them because I want to be.
I don't even know. I showed up multiple times to your court and you have not been there. And now y'all, this is, oh my gosh.
Remain calm, Mr. Ambrose. Please remain calm.
I am calm, Judge, but you are putting me in jail for things that you have actually failed to do.
I don't believe that's accurate.
Yeah, I showed up to court once and nobody was there.
Well, you may have come when there wasn't a court date. That's possible for sure.
No, there was. Oh God, I'm not arguing this. This is the worst court system, state court system I've ever dealt with.
Mr. Ambrose, this is full municipal court, so you may be confusing with
state
court.
Yeah, you're right. It is confusing. Thank you, Pat.
Yeah.
Oh my God, I'm gonna serve time for this. This is fucking.
We watched this judge give him an OR before.
So I just want to make clear, because of the prior history, although there may not be warrants that have been processed at the jail yet, there are warrants that will be entered on these cases. So just as that note, just for Ms. Aubrey's benefit, it's appropriate for him to be held on our charges, and that will occur. But what I would like to do is perhaps you all need to have another conversation. I know he just came into custody, but perhaps there can be another conversation that can be held with Ms. Butler to see what next steps defendant wants to take in connection with his cases.
Well, let me ask, on the other cases that have holds on him, does anyone know when those upcoming court dates are scheduled for?
I'm looking those up.
And while she's doing that, I asked our navigator, Niat, to join us because I don't know if you've had interactions with Niat yet, Mr. Ambrose, but he's one of our navigators here at the court. And I wanted him to just be aware so that he can communicate with the other folks that are part of his team and that are out, not just municipal court members, but people who work with mental health partners and those folks to make sure that they're aware of your circumstances.
I have a suggestion. Why don't y'all get my service animals back to me? That would solve everything. I'll leave your state If you return my service animals and pay me back the $250,000, I'm gone. I'll be out of Boulder, Colorado forever. Just return my service animals because you don't actually know where they are. And that's a federal offense. That I know that's the law.
Obviously, I
No,
can't.
that's federal law. It's different than state law. So I'm asking you to go ahead and talk to your attorney general, get my service animals back, which were illegally taken from me 5 times, and I'll just leave the state. How about that? That could be a deal.
Yeah.
And I'm not being sarcastic.
Ms. Aubrey, are we able to give him some information for Ms. Butler?
In at least one case, he's scheduled to appear today at 1:30.
Is that a state case?
It's for picking flowers.
It's a criminal mischief obstructing. He has multiple open cases.
State cases.
And those multiple open state cases, they are holding him in custody on those, correct?
Yes, he has another court date on May 14th.
Oh, somebody, sorry.
That's the state case.
I know, just trying not to be a smart.
On concealed weapon obstructing, resisting. So his nearest one is today at 1:30.
Gotcha. So I was trying to figure out, the reason why I was asking was to figure out if there if he was going to be held in custody on these other matters anyway. And it appears as though that is the case for Mr. Ambrose. So I think it may be best to set these matters, these municipal court cases out a little bit to see if there are any sort of resources that we might be able to get arranged for Mr. Ambrose while he's in custody. And then, you know, if we can, on his next court date, we can call him back and have a little bit better idea about whether or not there are any services that might be appropriate for him, and then also where his state cases might be.
There are no services in jail that support me. This only makes things worse. I'm letting you know what you're doing is called cruel and unusual punishment. I'm more intelligent than most people, and I don't mean.
And Mr. Ambrose, I'm going to interrupt you just because I want to clarify to you. I just want to clarify that what we just did with the judge and Ms. Aubrey is find out what other cases are holding you in custody as well as it's not just these.
I know, I listened, and I heard. Y'all are confused. You don't know how to actually treat people in your legal system, so you're creating harm right now. This is psychologically and physically what's going on for me at this current moment. That's the phenomenology of my body right now. You don't have the services in this jail to actually help me. You've already taken 24 hours of my life just in the last 24 hours where I cannot have my medication. Now, before you took about 4 weeks. Now you took my service animal. See, now you want to interrupt me. Go ahead.
Well, I'm not trying. We have to be reasonable about the conversations that we're having, Mr. Ambrose. I'm not. I know you're doing the best you can. I'm not. This is not critical of
a
you.
reasonable court system.
And I hate to do this, but I've got to mute you so I can get through the docket with you. And so, Pam, if you go ahead and mute him so I can be clear about what I'm trying to say.
Because I speak sign language.
That's fine. But I'm going to communicate so the group can hear me at least, and we can make a record. So I've heard Mr. Ambrose. I understand the concerns. I'm not entirely sure that the May date is an in custody date. So I don't want to set it too far out because that could be a date that's not an in custody date for him to appear. So let's reset this and let's put it tentatively on our calendar for just Wednesday, so that if there is some resolution of his other cases, we can at least address where he wants to go from here then, and you can have another conversation with him, Ms. Butler. And that,
Kelly, there is actually a plethora of phenomenology when we bifurcate these cases.
will allow you to perhaps look in to see when what he's got with those other cases and what his court dates are. All right, and then in the interim, Ms. Aubrey, we will make sure that the warrants and the bond amounts are set in these other cases for our court. All right, and I'll have a further conversation with Nihat. I just wanted him to be aware, so I can talk to you off the record about what can we do next. All right. Officer, if you're able to hear, we're going to have to move on to the next defendant. Mr. Ambrose, I want you to just hang in there. I know it's really difficult. It is not a perfect system. No one's saying it's perfect.
But wait, there's more. Just a different person.
The officer's muted, so we'll need to unmute again so she can be heard.
Okay, I'll bring the next person shortly.
Thank you, Mr. Paddock. Okay, good morning again. We've got Ms. Butler, just waiting on defendant. And who do we have, Ms. Butler?
We're going to be calling Shawn Post next.
Great, thank you.
And just, I'll put this on the record again once he joins us, but just to let the court know, I was having some difficulty kind of communicating with him and having him understand my advisement. So I'm going to ask if the court can provide him with an official advisement on these charges and kind of see if that's any clearer for him.
Okay.
Why don't you go ahead and sit down? We're in court. And Judge Kahn, this is Mr. Post had some trouble communicating with his public defender. I'll let her address what that was, but he expressed that when I came in after they met.
Okay. So, Mr. Post, let's start by just letting you know where we are. So you have a virtual, obviously a virtual proceeding here with the municipal court for the city of Boulder. There's one case that's pending for you for our court. It's a case from September 6th of 2023. The allegation, and it's just an allegation right now, is that you trespassed at 960 Green Mountain Drive. And you were expected to be in court for that charge. And when you weren't in court, I issued a warrant, or one of our judges issued a warrant for that failure to appear. So that's why you're in custody. It's a municipal court case. We appoint Ms. Butler to represent you. She indicated to me just a moment ago that there was some challenges as far as communicating with you. So I wanted to make sure that you understood your rights. You are completely presumed innocent of the charge. It's the prosecution's burden to prove the charge against you beyond a reasonable doubt. And you have Ms. Butler to represent you. If you decided to set the case for trial, we would set it for another date. We also have the opportunity, if you choose to today, to argue about what the bond should be in your case. So that's something that she can do on your behalf. But if you decide to go forward, you also have the opportunity, if you choose to plead guilty to the charge. The prosecutor would be recommending that if you pled guilty to the charge, they'd recommend that I impose 5 days of active jail and then suspend some additional jail time on the condition that you not go back to that location at 960 Green Mountain Drive for a period of time. So that's a plea bargain option that's available from the prosecutor. And I wasn't sure if you had had the opportunity to discuss that with Ms. Butler, but wanted to make sure you understand those are the options available to you today. Do you want some additional time to speak with her to go over all of these things? Or would you like me to go forward with the case now?
I still don't, it's still not registered.
When you say not registering, do you mean you just don't recall the citation that was issued to you?
I just don't, no. Well,
so let me pull that up and I'll pull it out for you and just tell you what I'm seeing. And if there's notes on it, I'll try to read those notes. That might help. Sometimes it does, sometimes it does not. But there was a citation that was issued. And it was, I can't even read the officer, I think Michelle, I think Leo, L-E-V. And it says that you were contacted, I'm turning my head because of the document I haven't rotated. Let me see if I can rotate it so I can look at it without tilting my head. It says that you were contacted for activating a number 4 exclusion from the University of Colorado campus. You were contacted at the main dorms. So that's what they've written, and that location is, like I said, is the Green Mountain Drive location. So that's why you received a summons. It's got on the bottom a signature on the summons, and that appears to be a signature. The person that received the ticket, I don't know if that was you, but that's what it appears to be. And so when you didn't come to court, that's why a warrant issued. So hopefully that gives you some backdrop to all this. Now, options for you. If you would like, you can have Ms. Butler argue about what the bond should be in your case. If you'd like to have another discussion with her, we can give you the opportunity to do that. If you need to come back on another date, we could reschedule your case for Wednesday if you'd like some time to think about all of this.
And Your Honor, if I may interject just quickly,
if I plead guilty or if I don't plead guilty.
I'm sorry, I couldn't hear you. Ms. Butler, what were you saying? Let's talk to Ms. Butler first, and then we'll talk to you again.
Thank you, Judge. I was just going to say, regarding the bond, just based on the email that I received from Ms. Keller this morning with the offer, she had indicated that Mr. Post would be automatically entitled to a mandatory PR bond. And I just wanted to verify whether or not the court shared that same position.
Yes, I do. So what that means is, Mr. Post, is you have the option today of pleading guilty and accepting the plea offer from the prosecutor, or if you would like to be released on your promise to come back to court, you have the right to request to be released on your promise. You wouldn't have to pay any money to be released, but you would be expected to come to court back on your court date.
So if I plead guilty, how much jail time do I get? If I don't plead guilty, how much jail time?
I didn't hear the last part. You said if you plead guilty.
How much jail time do I get? You get 5 days if you plead guilty. You get 3 days if you don't plead guilty.
If you plead guilty, you get 5 days starting from the date that you were brought into custody.
And if I don't plead guilty?
If you don't plead guilty and you want a PR bond, you'd be released and you'd still have the case open and you'd have to come back to court on another day.
Well, I might like to be released now, to be honest.
So it sounds to me like you'd like to have the PR bond granted for you and be released today.
But I have another court case in 3 days with a felony charge.
Are you still going to be in custody on that case?
I'm not sure.
Let's have Ms. Aubrey shaking her head yes.
He has an open warrant in state that has a court date of Wednesday. He has PR bonds in his other cases, but he has another case that he's set to appear in custody on the 17th.
Okay, so let me try to be clear with you, and it's really up to you. I do not want to try to influence you one way or the other on this, Mr. Post. Even if I give you a PR bond today, you won't be released on my hold. You'll be released on my hold, but you'll still be held by another court because you have another case. Does that make sense to you?
I still don't know which option to go.
Your Honor, if I may, so if I understood correctly, Mr. Post has his next court date in his state case in custody on Wednesday.
Right.
I wonder if it might be best to bring him back on Wednesday morning to this municipal court, virtual courtroom, so that we can address his municipal matters again, and it might make a little more sense with his credit for time served and his other case being set that afternoon.
That makes some sense to me. What time is he scheduled, Miss Aubrey, on Wednesday for the state? Do you know?
9 a.m.
Oh.
9 a.m. So right at the same time as us, or slightly before us. So it's possible that he could be done with, but it's also possible he could be sitting in that courtroom while we're trying to. So that's a concern, obviously. But I want to make sure that you understand, Mr. Post, you are going to be held, regardless of what I do. You're going to be held until Wednesday on their hold for the other case.
I'm not sure whether to plead guilty or not. Still, however.
Your Honor, It might help if I can meet with him once more in the breakout room.
Let's do it. We want to do this deliberately. So if it takes a little bit of time, it takes a little bit of time. So go ahead and why don't you go back into that meeting and see if you guys can have another conversation.
Thank you.
And I'll just point out before you leave, if he wants a PR bond, he's going to get it, and he could be done Wednesday, and then but he obviously has to come back. But I'll give him his PR today if he wants it, and then if he's still in custody on Wednesday, we would see him. But if he's not, and they release him, then we wouldn't see him.
Okay, thank you. I appreciate that.
Yeah. Okay, we're back. And Ms. Butler, just so you know, I did speak to Pam. He came into custody on the 12th, so he's got 3 days in already, as I think you both thought.
That's what I thought. And that there would be no question about how the jail calculates that.
That's right. Okay, I can see that Mr. Post is back. Ms. Butler, you've had a follow-up conversation with Mr. Post?
I have, Your Honor, and with this additional conversation I just had with Mr. Post and the clarification that we got on the record when we first called his case, Mr. Post would like to resolve his matter today and plead guilty to the trespassing charge.
Okay, thank you for that, Mr. Post. And so the charge that we were talking about is a trespass charge from September 6th of 2023. When you plead guilty, you're giving up your right to trial on that charge. Do you understand that, sir?
Yeah.
And are you doing that voluntarily today?
Yes.
Nobody's forcing you to plead guilty.
Yes.
No one's doing that?
That's right.
Okay. And do you understand this charge of trespass?
Yes.
And Ms. Butler, would you waive the factual basis for the charge?
Yes, Your Honor.
I'll go ahead and accept the plea. It is to the charge of trespass in violation of section 543 of the Boulder Revised Code at 960 Green Mountain Drive on September 6th of 2023. How do you plead to that charge, Mr. Post?
Guilty.
I'll accept that guilty plea. Any argument regarding sentence from you, Ms. Keller?
Nothing, Your Honor, from me.
Anything from you, Ms. Butler?
Your Honor, I just want to address Mr. Post quickly. The judge checked and confirmed how many days of credit you have that you've already served in custody. He did confirm that there are 3 days of credit for time served, so you will get credit for that for those 3 days. The total recommendation was 5 days. So by Wednesday, when you are going to court for the state felony case, that by that day you should be up to 5 days of total credit for jail time.
Cool.
So with that, I don't believe that we need to make the argument for 4 days of jail that you and I discussed, and I just wanted to explain why.
Okay,
and nothing further to the court, Your Honor.
All right, and I was going to make this also very simple because I'm going to make it a 4-day active jail sentence for the defendant. So there isn't going to be any issue for the other court or for the jail. That it'll be very, very clear that you're done with our case. As far as jail time goes, I am going to impose a no trespass order, though. I want to make sure you're clear about that. You cannot go back to any University of Colorado property for a 1-year period from today's date. So that includes the area where you were located on that ticket at 960 Green Mountain Drive. It includes CU property. Is that clear to you? And so I'm going to suspend 10 additional J's. You won't have to serve them, but I'm suspending that on the condition that you not go back to those locations. Does that make sense?
Yes.
Okay. And so for our record, Ms. Aubrey, it's 14 days, 10 suspended, 4 days active from April 12th, credit for time served, waive court costs. So that'll wrap things up as far as jail time for our court. All right, I'm glad we were able to get through that for you, Mr. Post. If you can just let the officer know that we're ready for the next defendant, and have a good day, sir.
Thank you.
Okay, I'll bring Mr. Nicholson next.
Sounds good.
Okay, this is the release of information that they talked about for your.
We've had enough. We've had enough of Colorado. Can we please go somewhere else now? Let's see. Okay. I don't know why, but my technology didn't crash, so I got my next clip ready. I didn't think it was going to be ready in time for today. And it's the whole custody and divorce thing, which is in my title. All right. I hope the audio is okay. The audio is not the greatest in this courtroom. I can hear it. I mean, it's a little rough at first, but then you get into your groove and you can hear everything. In the second clip, you can't actually hear everybody. Her lawyer is difficult to hear. Now, I did boost the sound, so hopefully that goes well. But just so you know, even if you can't hear all of what her lawyer is saying, you hear plenty enough. Plenty. Here we go.
Right. So all those will be testifying, if you raise your hand, to be sworn in. Do each of you solemnly swear or affirm that evidence you give will be the truth?
I do.
I do. Thank you, Mr. Davis. You may proceed.
Yes, if it pleases the court, I will, first of all, Carolyn K. Kincaid to testify. You've just been sworn in. Would you name for the court, please?
K. Kincaid.
Okay. And what is your residence? And you're here in court today with Buford Daniel Kincaid, is that correct?
Yes.
All right. And did you on...
Sorry, if you see it skipping, I did try very, very hard to remove the thousands of times they said the minor's name in this court case. I hope I didn't miss any. I don't think I did, but that's what took me so long. That's why it wasn't done until the very last second.
March 12 caused me to prepare to execute a petition for appointment of guardians.
I did.
Okay, and that was the same day, and you did that under oath, is that correct?
Yes.
Okay. And so the allegations in that are, to the best of your knowledge and information, true, is that correct? All right. Now you're asking for a guardianship for a child who was born on what date?
2014.
Okay, and he was in the courtroom just a minute ago, right?
Yes.
Okay, but he, outside the courtroom with
his uncle.
With his uncle, okay. And what are the circumstances that you can recall under which he came to be in home?
We received a phone call shortly after noon, August 30th, 2023. We told our grandchildren prior to that, if they ever needed our help, to call us and we'd come and get them. Well, that call came on the 30th of August, 2023.
From whom?
It's Bishop Kincaid and his brother Aiden Daniel that was talking on the phone call. And he was scared and trembling, and he asked Grandma, how soon can you and Grandpa come and pick up me and Aiden?
And where were they?
They were at a motel that they had just checked into earlier that day. By themselves. Oh, excuse me, on the 28th, they were at a motel by themselves.
Okay, and what motel was that, do you recall?
It was, I believe it was Daylight Inn on Cassopolis Street in Elkhart, Indiana.
And did you, and explain about the other brother, what's his name?
His name is Aiden Daniel Kincaid.
Okay. And he's an adult, is he?
He is 21 years old now. He was 20 when we
picked him and his brother up at the motel room.
And what is his situation?
He is autistic. He is mentally challenged. He's disabled and needs supervised care.
Okay, but Aiden is now a member of your household, is that correct?
Yes, he is.
And of your household, is that correct?
Yes, he
Okay.
is.
And is Aiden working?
No, he
Okay.
is not.
And both you and your husband are retired, are you?
We are.
Okay, and you're.
Technical issue. I'm going to fast forward a little bit.
And
There we go.
you and your husband are the recipients of that and handle it, is that correct? It's on a card or something like that?
Yes.
Okay. Does he have any other assets
No, he does not.
aside from
Personal
clothing and personal belongings and that sort of thing? Okay. And no other sources of income to your knowledge?
No.
And you want to describe for us the scene when you went to pick up these two young men?
They were scared. They were hungry. They were left alone at a motel that they had just checked into the day their mom and stepfather were arrested. They'd been gone, they'd been alone it was the third day, 3 days by themselves in a strange place with no food.
Okay, so, and to your knowledge, their mother and her friend, Christopher Hutchinson, her husband, had both been arrested, is that correct?
Correct.
Okay, and it's our understanding that the mother of these two children is now currently charged with possession of methamphetamine, class 3 felony, and possession of a narcotic drug, a class 4 felony. Is that correct?
Correct.
Okay. And she's here today. You see her in the screen. Is that correct?
Yes,
And
that is her.
And that's your daughter.
That's our eldest daughter.
Okay. So, and with I think you had experiencing in the custody of Mr. Hutchison and your daughter. Can you talk about that a little bit?
They were mentally, emotionally, and physically abused, starved.
And you're drawing this conclusion from him and his brother have related to you, is that correct?
Yes.
Okay.
They have been homeless, sleeping in sheds outside in neighbors' trailer court yards, sleeping in storage units. They have been hungry and disciplined for wanting food, yelled at for eating food that they weren't supposed to eat because it was for their mother. Those children were hungry.
They can have my Doritos.
And they were reprimanded for it.
Okay. Now, you picked both of these boys up, is that right?
Yes.
Okay, and brought them to your home.
Yes.
Okay. And tell us how Particular has been getting on since he's been in your home.
He's been enrolled in school.
What school is he going to?
He goes to school in Indiana. He is attending school like a normal school-age child for the first time since kindergarten.
That's absolutely not true.
He has attended school, but not on a regular basis with them. He is doing well. All of his teachers, his speech therapist, and all of his teachers are very pleased with his progress. He's in attendance every day. He's excited about going to school. In fact, he didn't want to come today because he's missing art class and sub sandwiches at lunchtime. And he is thriving. He's doing very well. And he has made a lot of emotional and educational progress.
Did you seek and obtain a protective order?
Yes, we did.
Against whom?
Christopher Hutchinson, their stepfather.
And is that protective order still in place?
Yes, it is.
And that was on the basis of what?
That was on the basis of what Liam and Aiden told about the physical abuse that they endured, which has been medically documented on some of it. Neglect on prescription medications on his older brother Aiden. There was a 911 call that I had made to the Elkhart City Police based on the abuse that Liam came running out of their house saying, Grandma, Chris is beating Aiden. The police came out to their house and then sent the two boys back in to be with them for 2.5 more years of abuse and neglect without calling Child Protective Services or anything of that nature.
Okay. You're saying that Liam is thriving for custody, is that correct?
Yes.
Okay. And you and your husband are
The husband will speak soon, but he doesn't say much.
Fed them, washed their clothes, I changed their, I potty trained them. Our home has been their home, born in our home, and our home is their home. And I told Mr. Davis that for the past 21 years, they have been the air in our lungs and the beat in our heart and the reason for living. We love them and we will love them forever. And we've worried about them for 21 years as well.
so you're asking the court to appoint you to be guardians for, is that correct?
Yes. May I say one more thing?
Yeah.
We made a promise mandate in both on August 30th of 2023 when we got home with them from the motel room that we would do everything in our power to make sure that they would never have to live like that again. And we just ask perfectly and respectfully that you would help us keep that promise we made to these two boys.
Okay, and you have, and your husband have executed a guardian oath saying that you will faithfully discharge your duties as guardians. You understand that as guardians, you're going to be responsible for Liam's person and that he's taken care of, that he gets medical care, gets food, that he gets shelter, raiment, all of the things that he does need.
Yes.
Okay. That if he does come into some money at some point or another, you're going to be responsible for that as well. You understand that?
Yes.
Okay. Judge, I'd like to submit to the court the guardian's oath that has been executed by my clients. Sure.
And Mom's coming soon. We're gonna see Grandpa say a few words, and then here comes Mom.
You're also asking, are you not, that bond be waived in this case?
Yes.
Okay. And if you are appointed guardians by the court, you will be submitting, before we submit a final decree, a petition to excuse a formal inventory and a biennial accountings. Is that correct?
Yes.
That's all the questions I have for Mrs. Kincaid.
Pardon?
I would ask Mr. Kincaid, or you don't want to ask for cross-examination?
No, I'll give him a chance to talk. I would just present the guardians.
Okay. Mr. Kincaid, would you please state your full name?
Daniel Kincaid.
Okay, and you've heard the testimony that your wife has given in this case?
I have.
Okay. Are her representations to the court true and accurate?
They are.
Okay. Is there anything else that you would like to add to what was said?
Other than neither boy had been to the doctor for 3 years. So,
not true.
Okay. Anything else?
Not
okay.
really.
But you did take both boys to the doctor after you picked them up, and
We've got them, we're taking them to the doctor and the dentist. And got them.
All right, hold on. 1 second.
To the guardianship of the.
I think that's all.
We're taking them to the doctor and the
Uncut
dentist.
version.
Got them, and the eye doctor.
Okay. So you're taking care of their health needs right now?
Best we can, yes.
Thank you, that's all.
This is mother's opportunity to respond and ask the potential guardians any questions you may have.
Okay, first and foremost, they had been to the doctors. Liam had recently been to the dentist and had caps and molars capped. Both children had had medical care.
I didn't say dentist.
Liam has never not attended school. He was enrolled in Mishawaka and was being helped out through the McKinney Bento program to make sure that transportation was provided even though we had been displaced. He has never not attended school. He had counselors and special help there and an IEP in place because of his dyslexia. He has always been in school. We have never not had him enrolled. My parents did call CPS. CPS came and saw me here twice since I've been here at the Elkhart County Jail. I have paperwork in my possession right now, signed by Emily Kuhn, stating that both accusations were unfounded and they closed the case. There was no abuse or neglect noted from DCS. The night that we were arrested, we had left to go pick up a small fridge for the room because there was no way to keep food there. I spent the first 4 days of my incarceration telling every guard, every police officer, every person at the hospital when I was taken to the hospital before the jail, that my children were at the hotel and that they needed assistance, that no one sent them. I finally sent someone who bonded out to a friend in Elkhart who went to the hotel and assisted them to call their grandparents. They were never abandoned. They were never left there intentionally, and the police officers at the scene were aware and did nothing. I have always taken care of my children. The 911 call that she is referring to, they were never abused by their stepfather or me. They were hungry at the hotel when they got picked up because we had been detained and unable to return at that point. There has never been a lack of food or protection for them. They have always been able to eat. We were staying with friends for a short amount of time that had food that was specifically for them. There were instructions given to the children not to eat food that didn't belong to us, but they had food available that was ours. I have never had food that was specifically for me over my children. I would have gone hungry myself first.
And she has. Please don't interrupt our proceedings.
Both of my children have a legal POA that is available and accessible to work with my parents. That was never intending to remove them from their physical custody. All we had requested was that they include us in the children's lives at this point and in the decisions. They have refused. My mother has hung up on me, refused to allow me any type of visitation or contact with my children. I have called repeatedly. I have sent Christmas gifts, letters, birthday cards. No response at all from them to even let me know if my children received these items.
Please don't interrupt the proceedings.
I have, even from jail, continued to try and take care of my children. And they have refused to even allow me to see them or speak to them. Guardianship at this point, if it is temporary, I am not trying to remove them at this point. But I do not agree with or acknowledge the accusations of ill treatment. They need a home right now. That is not the question. I respectfully request that you grant temporary guardianship until my release and until I have access to a stable home for them.
That'll be never.
Also am requesting that I be allowed to visit my children, that I'm allowed to speak to them, to have phone calls with them. I have never tried to exclude my parents from my children's lives. They have distanced themselves because of their personal opinions about my husband. That is their choice. It does not change the fact that the children were cared for. I have school records, I have dentist records, I have doctor's records. They have been cared for. And I have 2 closed DCS cases that back up my side of this story.
She touched her hair, guilty.
Yeah, I didn't ask your mother, but do we know who the father of Liam is?
No.
I think that's all.
Thank you. This proceeding is only about Liam. It's not about Aid, and there's no matter before the court concerning that 21-year-old individual. So my ruling is only is going to attach to the scope of this hearing, which is concerning Lyman. I will take judicial notice of the following causes of action. Court, please take these down. Cause of action mother has is 20C 01-2308 F3 33. Although I don't believe the stepfather is a necessary party here, to have notice of these proceedings. But I do note in regard to the stepfather, he has pending 20D 04-2308 F5 209. Also want to make a part of the record the protection order 20D06-2311 PO 1040. Based upon the testimony I have heard, I will grant the petitioner's guardianship of the state and the persons of the minor children herein. And counsel is to inform the court's approval. Will waive the inventory and accounting. They want to have an annual report. I know that well, but being it, I'm very concerned about the people under my charge and guardianship, since I like to have the status report. It's a very simple report, at least on a yearly basis. I do believe that some type of parenting time is probably appropriate. I am not sure the exact mental health or situation of Lyman, so I'm going to appoint a guardian ad litem to more fully investigate that case before I make that decision. But I do think that sufficient evidence has been presented today for me to grant the petitioner's guardianship of the person's state of the child.
Judge, I have the guardian's petition to excuse formal inventory and petition to excuse biennial accountants. May I say that?
Sure.
One signed ahead of your order, but assuming that we might get it. So, and I have an order appointing guardians that I can give you. It does not include a specific direction for annual account. I can supplement that if that would be all right. Or do you want me to just hold on to this and give you?
Yeah, more where you prepared today.
Yeah.
I think we can act by supplement.
Oh, you'll take care of it.
This is Indiana.
Thanks, Judge. Here are those.
I'll take a moment to review the proposed order.
And don't worry, guys. That lawyer sitting in the blue right there, we get a better look at her outfit, which is on point, by the way. Damn, her shoes aren't orange. You're right. Oh, fail, woman. That's a big fail. I hope your client loses.
I have a side note where I tender back 2 signed copies to the petitioners. The other copy will be a part of the record. We will then send it to the mother. And I will also do dictation. That'll also be distributed to the record. That will conclude our proceeding on this matter.
Thank you, Judge.
The custody on the hearing, guardianship evidence is heard. That's now guardianship. Finding the right house with abandonment by mother. Yeah. It's on All right, so we have, your client is on WebEx and, her husband and her counsel are present. And I guess what I'd like to just simply start with you, Bluefield, and preliminary comments about the situation. And we did establish, Mr. Lawrence, that you're also representing her on the protection, or at least that's what she said. Is that correct?
That is correct.
All right, thank you. I just need to have you file an appearance. I'm fine with, showing you've entered your appearance, but I do need the actual formal document if you file that, please, in the PO.
Yes, sir.
All right, thank you, counsel. I'm gonna ask Counsel Littlefield if she has any preliminary comments as we begin today.
Your Honor, this case started, I think, with our petition for dissolution of marriage. It almost crossed in the mail, I think, with the protective order that Ms. Fox Civils filed on her own. We would like to have this protective order dismissed. We would like to have a no contact order be placed in the divorce. It gets the same job done. If that's not the inclination of the court to do, then we would ask to set this matter on the protective order for an evidentiary hearing as soon as possible. As the initial allegations in the protective order would not, in our opinion, stand through an evidentiary hearing and be continued on. I know the court does protective orders out of an abundance of caution, but in this particular situation, it is clear that there has been no domestic violence in this case, and it wasn't even alleged in this description. So we are just asking, first of all, to have that dismissed, and then we'll address the motion for provisional orders if the court would like us to do that.
Sure. Now, do counsel have a position that, I don't know if you could hear Ms. Littlefield completely, but she said she's asking the court to dismiss the PO and just enter a no contact order in the divorce case, which basically have the same effect of the PO. And this is your opportunity to respond to that request that she's made.
We couldn't disagree with the petition. This is the restraining order was placed and it was properly placed. This is the case where the husband turned off.
He's hard to hear, but you don't need to hear him. You'll know what he said as it goes through.
The water heater. He
Husband turned off a water heater.
the cabinet medicine
Locked the medicine cabinet.
depriving my client of access to medicine. My client is extremely sick. And
Your Honor, I must object not to interrupt Mr. Wasso because we had a very good conversation yesterday, and I have a lot of respect for him. But there is no allegation in this protective order about turning off a water heater. I believe that's something that Ms. Fox Civil sent to your staff in an email. And there has been also no allegation in this protective order, which is what we have to use for the basis of this protective order, that there was any locking out of any medications by my client. There is no lock on a medicine cabinet, and that's not even in this particular protective order petition. So we'd have to object that that's outside of any allegation that's been made and considered by this court.
Thank you. Anything else, Mr. Lasso?
yes, Your Honor. If I may quickly pull up my notes here on that particular point. It was actually that the respondent to file the order after they realized some of the facts that we are talking about. There was the husband locked the freezer, deep freezer, depriving my client of food.
Again, I'd have to object, Judge, that is nowhere in this protective order, which is the basis for which we have to consider whether this should continue or not.
Thank you. I'll give you one more shot, Mr. Lasso, to make comment on the protective order issue.
Your Honor, if that is the position of the petitioner,
I don't think that's necessary. I think I can protect the petitioner. I can protect her by orders of a no contact order, and I can take care of all the access to the home, all the stuff in the divorce case. I think the protection order just kind of makes it more confusing. Now that we have a divorce filed, I can fully protect the petitioner, Mr. Don Silvius, to protection through a no contact order, which I will vigorously enforce if it's violated in the DR case or DN case. So I have heard arguments on that issue. I'm going to dismiss the protective order 313. Let's move on to orders in the divorce case, provisional orders. I'm going to give counsel this present report a little bit of opportunity to comment on that. Then I'll give counsel for wife opportunity to also respond. Go ahead, Ms. Littlefield.
Thank you, Your Honor. We filed for the motion for provisional orders because we knew a lot of strange things were happening, and we requested that the court set the provisional hearing immediately or as quickly as the court could because of all of the calls to the police that Ms. Fox Civils was making. As you'll note in my attachment on the motion for provisional orders, the police officers had to advise Ms. Fox Civils that they were not going to violate my client's rights, that they obviously weren't responding to any crime that would have been alleged, and they apparently were complained on by Ms. Fox Civils after this officer refused to violate my client's rights. So we immediately and quickly filed a motion, the petition for dissolution and a motion for provisional orders, because we just had a sneaking suspicion that he might be seeing some sort of protective order, and we weren't disappointed. Now that that's over with, the problem is this was a house in which he lived, obviously. He was, withdrawn and actually not allowed to be in the home. And he is the person who has been taking care of the home, paying for the home, providing everything, and he has nowhere really else to essentially go. I mean, he could stay places here and there, but this is the home that he has taken care of for the majority of the marriage. We are asking, Judge, that he be granted temporary and exclusive possession of the marital residence, that he would pay for that marital residence and the expenses thereon. We want to make sure that he would have temporary and exclusive possession for certain. It is my understanding from speaking with my client that his wife has been in the process prior to this protective order, been in the process of potentially looking for places to move to with her adult son who lives with them as well. He is apparently out of high school, full-time job, and would be moving out as well. The thing that actually spurred on this problem, I think essentially the straw that broke the camel's back, is when my client indicated that after some discord in the home that he wanted to evict the son from the home because the son was attempting to provoke conflict. After that, we started facing all of these problems. It is completely possible for Ms. Fox Civils and her son to live elsewhere. My client has recently sold a vehicle of the marriage, has money to provide to Ms. Fox Civils in order to get her set up in whatever apartment or something to that effect that she would need, so long as she would be able, to go within a reasonable period of time. I mean, this is not a situation where we can have anybody cohabiting. He is willing to pay that money to her in lieu of like an advance on the settlement, that sort of thing, and make sure that she has enough money to secure an apartment or a house rental of some nature. We obviously would want everybody to be responsible for the debts in their name as a temporary order. Also, that my client would request temporary and exclusive possession of the Chevy Silverado and a Jeep. That he be responsible for paying on the Silverado. I don't believe that that Jeep has any payment on it. We are saying this, and I'm guessing the court would say, well, what about the vehicle for the wife? What vehicle is she going to have? Well, she can't have a vehicle at this point because she can't drive because she does not have a valid license. Her license, I believe, is suspended. She has driving while suspended issues and has no ability to legally drive a vehicle at this time. She gets around by having her son drive her places because apparently he is a licensed driver. My client would also ask that everybody would continue to keep his and her separate bank accounts as they are. There is a sum of money in the Everwise bank account that is from the sale of that vehicle I referred to earlier. We asked for to award her 1/2 of that sum, which would be around $3,000, I think, maybe 3,200 or maybe 3,000 or so, as far as that to aid her in securing alternate residence. So we don't have the argument of she has no money, she has no job, she can't live anywhere else. Well, the issue is she has had a job. She has worked at places like Dairy Queen. She has been terminated from those places, but she does have the ability. Now you're going to hear that she is disabled. There is no disability finding. The Social Security Administration has not found that she's disabled. Apparently there was some sort of letter, a couple of letters from a nurse practitioner in her corner that was saying, wow, she can't work, she's so disabled, but that's not really been the case. She has had issues with her health in the past. They are not issues that can provide her to be in a situation of being disabled. And I would suggest that my client, if the court would agree, that the sum of money, not just half of the sum of money, but the entire sum of money, which would be $6,000, be provided to Ms. Fox Civils at this time, so long as she would then be removed from the home and secure her separate residence. We also would ask to reserve the right to claim any principal reduction on the mortgage and debt reduction after the credit, after the settlement, and be credited thereon. Obviously, we have the no contact order that I'm assuming will be reciprocal. So that takes care of my section, which says to prohibit harassing each other. We would also ask for the court to order that the parties be restrained from encumbering, transferring, selling, or otherwise dissipating any marital assets. Judge, rather than getting into the back and forth of all of the arguments, I just wanted to make my argument clear that my client is willing to provide a sum of $6,000 to Ms. Civils in order for her to leave the house, so that there won't be any of this discussion about how she is incapable of being anywhere else. We know that she has been looking for alternate residences. We know that she will be living with a son who has a full-time job. With this money, she will be able to remove herself from that home. I don't care if anybody considers that to be spousal maintenance, an advance on settlement, whatever the case may be. Ms. Fox Civils is not going to be capable of caring for this house and a lot of things in the house. The house will depreciate if things aren't cared for. And my client would ask that a reasonable amount of time, such as 2 weeks to 30 days, for her to remove herself from the residence would be appropriate. I think that's all we have, Your Honor. Thank you.
Thank you, counsel, for wife may respond.
Thank you, Your Honor. Your Honor, from evidence in support of my client's position, also it was at the last minute because the case just started. I just was hired. I don't know if the court had an opportunity to see that my client's document has been the letter stating that
she's disabled, she can't work, she deserves to get the house.
My client is extremely sick, Your Honor. She's been in this relationship for 11 years. She's been in that house for just that long. He doesn't work. He hasn't worked full time for the last 7 years. He is completely dependent on the financial support and the familiarity of the property. So she would respectfully ask the court provisionally to allow her to stay in the house and have the husband pay the expenses of the house. So, other support.
Her lawyer knows, though. He does say at the end, if you're kicking her out, at least give her 30 days. So he knows what's coming.
And I don't know what to support. She's extremely sick. She under severe medication. She cannot drive, not for the reason stated by the petitioner. It's actually because of medical condition. Again, Your Honor,
He's saying she can't drive not because of what he said or the lawyer said. It's because she's disabled. But really it's because her license is suspended.
She is really unable to perform. So to put the burden of having to leave the family that's running like the house in such a short time, that would cause even more anxiety or stress to my client. Your Honor, she's taking 4 medications as we speak. Sometimes she is not aware of her surroundings. She has to have the funds to take her to her medical appointment. And it would really cause an extreme hardship if she had to leave with such notice. Unfortunately, the petitioner has told my client's car and took the money, refused to give it to her, only on the condition that she leaves the house. He still has the money, even though my client asked for it. And only if he can move things. If my client's sister can move.
Yes, this is her attorney talking. But his connection is bad. We can't hear him really well. But that lawyer can hear him, and she's about to get him.
Condition, financial and particularly mental condition. The familiarity of this one would be very helpful. She would like some time to leave, not the conditions the petitioner is talking about. Of course, if my client has been working full time for the last 7 years, we will respectfully ask the court to order the petitioner to pay my fees, my initial fees. For now, we will ask the court for $1,500. That's it, Your Honor.
Thank you. There is a local rule concerning attorney fee grant, so parties may certainly review that and submit the calculation to the court. So attorney fees are something controlled by local rule. We do have a calculator actually available online to do that. So you can, I certainly will consider that. Once you do the calculation, local rules, and I'll certainly consider that. I will certainly order the no contact order between the parties. That is no contact in any way, shape, or form. And as I said, I will vigorously enforce that if it's violated, even I am dismissing protection order. I think that from what I've heard, I will allow the vehicles to be in the husband's possession and have responsibilities for those, and that wife cannot drive at this point. I would also order that he turn over the account, you said about $6,000.
Did you say it was 6,000?
Yeah, $6,500.
$6,500. Turn that over forthwith to the petitioner, to the wife, and certainly we can reserve that issue as to if it's applied to the general property settlement in the future. And I would give her 30 days to find other accommodations to live. Hopefully, turning over that money as quickly as possible will assist her to find alternate housing. And then once she is out, then the husband can retake the property and care for it. And again, all those issues can be certainly more formally addressed in your final settlement. And certainly no dissipation of assets of any nature. And again, counsel can submit the calculation concerning attorney fees for consideration. Anything else from?
Your Honor, knowing that there is a $6,500 amount of money going to Ms. Fox Civils at this time, we would ask that the attorney fees, whatever they would be included in this sum that he is going to be turning over, because that's a pretty large sum of money, and he no longer has any for attorney's fees either at this point, I wouldn't think so.
Let me look at the calculation
Okay.
first.
Yes.
I mean, that really.
All right, thank you very much. Thanks.
Anything else from the wife's counsel?
Your Honor,
May I?
30 minutes from the time that the money is given to her.
No, ma'am, you don't get to say anything.
How would we like that to be done since there is a no contact order? I mean, is she on that account?
No, she is not.
Okay, so how would we want to, I don't want to get him in a situation right out of the bat. How would we like to get that accomplished?
Tell me.
I can get a cashier's check from the bank
Okay,
in her name.
and
She can come.
then she can come to my office.
So we're gonna have a cashier's check at counsel's office by sometime tomorrow.
3 p.m.
I cannot do that. I cannot do that. I will not be there after noon.
We can have it by Monday.
Monday,
the April 22nd.
okay,
Does that work for counsel?
double check.
Is that me, Your Honor?
Yes.
Yes, Monday, April 22nd, there'll be a cashier's check at Ms. Littlefield's office for wife to pick up, and 30 days will start running that day.
Okay.
All right, anything else?
No, thank you, Your Honor.
That's it for me.
All right, now we'll
Hold on, I'm typing. So that she has to get out. She has 30 days to get out. She's going to get $6,500 from him to set up her new apartment, which she will not be able to pay for because she does not have a job. And she says that she is disabled, but she's had jobs before. And then she gets fired from them. Bondi. I'm going to Bondi where the lifeguards are. Oh, yes. Oh, help. I'm drowning. Please help me. I'm practicing. I'm practicing now for my oh, help. My oh, help screams. Oh, impressive guards. Okay, I'll go to where you are, Carolyn. And in the first case, yeah, I don't know. I mean, we all know that the mom is in jail right now for possession of meth. And so is the stepfather. Not that he's in the picture. I mean, he's never going to get custody of the kids. They're not going to give the kids to the stepfather at all. But we have seen it a million times. Possession of meth charges they get released right away. So she's going to get released right away, but she's not going to get the kids. She's not going to get the kids until she gets stable housing, maybe. And then the court will figure it out from there. They're with the court now, so it's up to the courts now, and you know how that goes. She got a guardian ad litem who will, make sure everything's okay. Most likely she'll have to take a bunch of drug tests before she can even get parenting a visit. I don't know. But bravo to the grandma and grandpa. I mean, they had to take the kids. They had to. I think that guy in the green that sat there with the folder the whole time was an uncle. I'm not sure. I just remember her saying something about an uncle. He, he doesn't look very much younger than those two. So I don't know if he's in the mix to get the kids either. I just don't know. I hope it doesn't turn into that. I hope it doesn't turn into a battle. They're fine where they are. And I mean, if my daughter was in and out of jail and my grandchildren were suffering for it, every single day of the week I would pick my grandchildren's side every single day. So can you obtain update of woman who fed poisonous mushrooms to family in Australia? Yeah. Well, I did see in Kansas. In Kansas, there's a case coming where this guy's charged because he came upon a police scene and he ate the leg that was left there. He ate the leg. And now he's in jail because he ate part of the crime scene. Every time I'm feeling froggy. Every time you think you've seen it all, man, you've never seen it all. There's always something worse. The adult son, I don't think could have a full-time job. Oh, you mean the second case? Yeah. I mean, the adult son apparently has caused issues in the marriage, and that's why they're headed for divorce. Yeah, absolutely. You always side with the children. Always. Always, always. So, over the weekend, Judge Fleischer doesn't have court, obviously. So that's why I was able to get this great big pile of crazy today. I love Judge Fleischer. I am absolutely not going to stop getting Judge Fleischer. But when I get Fleischer, I don't get enough time to find this craziness, and it feels good to get some of this craziness again. Anytime we have to painfully sit through Miss Butler, it's a good day. It's a good day. But this court right here, this is at Elkton, Indiana. And I've gotten Indiana before, but not this judge and not this courtroom. This was completely new to me. There was another new one in South Dakota, I think. And I wanted, so every time someone came up in front of the judge, I was just praying that they would do something crazy so I could show you this courtroom, but they didn't. It was just a boring day for them. But maybe next time. Keep your fingers crossed, guys. Maybe next time. All right. What time is it? Oh, all right. I think I might have time to get one more the Australian judge, one more section uploaded to my Patreon. You can join the Patreon for free. You don't have to pay money to join my Patreon. Everything I put on there is open to everybody, not just paid members. I think I am gonna put some, I tried to do it today. I tried to put a 10-cent t-shirt on for the members, but it wouldn't let me just put it on for members only. So I have to figure some other way to get t-shirts to people. But I'm going to put another section of the Australian trial up there today. I did also put the entire Judge Fleischer trial, day 1 and day 2. But remember, there's no verdict. There is no verdict. I already know that I'm going to get some comments saying, why did you make us watch this when there's no verdict? And that's fine. That's perfectly fine. I have Tara Beard in chat, in comments, that'll get you if you say that to me. She's going to get you. She will. She won't hold back. But yeah, I'm at least going to edit part 5 today if I don't have time to upload it before I have to start recording the courts. Then I'll do it later. But Carolyn, love you too. All right, guys. I'm still working on bingo. I have 34 excuses ready. I need 75. Once I have 75, then it'll have to be electronic, and they're free bingo cards, because if you pay for them, it's gambling. So, thanks, Cloud. I am. It's the weekend for me. I'm off today. I have big plans at noon, and then after that, I'm probably just going to sleep all day. While court's recording, I'll wake up every once in a while and make sure I'm recording something, and then I'll go right back to bed. Oh my. Thanks for coming out, guys. Thanks for making it the whole way through this craziness of cases today. I am going to get my courts set up, and I will talk to you probably in about 24 hours. Yeah, true, Tina. Have a great day, guys. And don't forget to replay and watch chat. Chat is hilarious today. Hi, Taze. No one here sleeps. No one in my chat ever sleeps. Even though a couple left to go to bed, but they don't count. But they count, but they don't count. Bye, guys. See you next time. Behave.